part to control the legal rules that apply and to limit or change, in many cases, the various rules in the various jurisdictions that would otherwise apply. So this diagram is just an example to show the relationships in the context of a credit card system where, for example, in the Visa system, you've got multiple banks issuing multiple cards to multiple users who then use those cards with multiple merchants who then pass it on to multiple processors and so forth and so on. You've got a huge system, many different roles, many different participants, and ultimately crossing all kinds of jurisdictions. You can take that same picture and take out bank and put in identity provider or attribute provider and change merchant to relying party. And in essence, you have a diagram that's generally applicable to an identity system as well. So what's the framework for identity systems, and how do we interact with it? So I want to posit that there are three levels of law apply when you have any multi-party system, whether it's credit cards or whether it's identity. And I want to take you through these three levels to give you a sense of what exists at each level and where you can exert some influence or control the rules that might apply to a given identity system. So we'll start with general law, then we'll talk about law specific to the type of multi-party system, whether that be credit card systems or whether that be identity systems. And finally, we'll talk about system-specific rules, which is really where you want to be because that's where you have the best opportunity to really control the legal rules that apply and set it up and structure it in a way that works best for the participants involved. So general law. General law is law that's been around for hundreds of years, potentially, right? It's very basic law. It's statutes, it's regulations, common law through court decisions. It's the law that governs the stuff we do. The source is a government, obviously, a legislature, a court, a regulatory agency, and so forth. But the key thing is, it was not written with identity systems in mind. In fact, most likely it was written before conceived of. And it covers all kinds of things. I've listed some simple examples here. Contract law is obviously going to apply when you're using contracts and how you form contracts and when you're in breach and what the damages are and so forth. Tort law, negligence, fraud, misrepresentation, big potential issues in identity systems. Privacy law obviously is huge, but just to kind of illustrate, I've included in this list family law. And you might say, well, what the heck does family law have to do with identity or an identity system? And for the most part, it doesn't. But you can certainly posit an example where, for example, a couple, a husband and wife, one of them has an identity credential bound with a private key or with a password or whatever it is. The other spouse uses that to enter into a transaction, let's say. If the first spouse says, wait a minute, that was not authorized, I shouldn't be held responsible for that transaction, how are we going to decide that? It could well be we look to family law to say when and under what circumstances is one spouse responsible for the actions of the other. So you're going to get potentially a lot of very disparate areas of law potentially applicable. If we look at some of the sort of the common issues that come with systems, for example, we can see that the collection, use, and transfer of identity information is certainly regulated by privacy law to the extent it exists. And for those of you dealing with GDPR, there's going to be a huge impact of GDPR where it applies in an identity system context. Or laws governing, for example, the use and communication of Social Security numbers potentially could have a big impact. What about the accuracy of identity information? Okay, the basic tort law the law of fraud, the law of negligent misrepresentation, warranty law, all of those kinds of things, common law written outside the context of identity systems, but will likely be applicable within the context of an identity system in a variety of situations. Retention and availability of identity information. Again, privacy law comes back into play, as does the law we see increasingly in the states in the US governing record retention and record destruction. And of course, security is a huge issue, and we're seeing all kinds of laws requiring data security. So I want to sort of build my chart here. So this is the first layer. This is what we're looking at when we look at these three layers. So this is the first one, general law. And I call it public law because it comes from a government, right? Whether it's a legislature or a regulatory agency or a court, it comes from a public entity. But let's look at what are the problems with this general law. And I want to highlight some of these just to kind of point out that this is what you want to potentially change if and when you can. So as I said before, general law was not written for identity systems. And so as a result, it may be a poor fit in a number of situations. We have the law of negligent misrepresentation that apply to an identity assertion, and if so, when, and if so, who's responsible, and what's the liability, and so forth. Not really entirely clear. Existing general law may create barriers to the operation of an identity system. The most obvious barrier, of course, if you're a data subject, you wouldn't consider it a barrier, but the most obvious barrier is privacy laws, because they restrict what you can do with the information that you want to collect and use in the context of an identity system. Existing law, general law, may lead to inappropriate results. It may impose liability on a participant in a situation where perhaps it's not considered appropriate in the context of an identity system, but because we're applying an old law written in a different time for a different purpose, it may give us a bad result. And primarily, it leads to a lot of legal uncertainty. What exactly is my liability if I'm making identity assertions? What is my liability if I'm a data subject and I misrepresent something about my identity? There's all kinds of questions out there. But the bottom line is, in many cases, we don't have a clear-cut answer under existing law. And in many other cases, we have answers, but they differ from state to state or from country to country. And the law of misrepresentation is a good example. Literally 20 years ago, we did a huge study looking at all the state laws and their applicability basically to identity systems. One of the laws we looked at was the law of negligent misrepresentation. When am I liable for an identity assertion that is incorrect? And you would be amazed to know the states are not consistent on this issue at all. It varies from state to state. There's probably 3 or 4 different approaches that the states take. But if you're running a system that crosses borders, you end up in a situation where you're not really sure what the rules are. So from a trust and an interoperability perspective, this general law doesn't particularly help, although in some limited cases it does. Obviously, if you're the data subject and you've got a law like GDPR, it gives you more confidence at least that your data is not going to be misused. But for other participants, not so much. So let's look at the second level of law. And this is new. This is just developing. But this is law that governs a particular type of multi-party systems. So for example, in the credit card arena, we have a law, it's called Regulation Z, which is issued by a federal government agency that regulates credit cards. That's the law that says you're not liable for more than $50 if you lose your credit card. That's the law that says if I want to issue you a credit card, I've got to make a disclosure of how many days you have to pay and what the interest rate is and a variety of things that you typically see in that box that always appears on the credit card solicitations. So that is law focused on credit card systems. It applies to Visa, MasterCard, Discover, American Express, all of those individual credit card systems. And it doesn't govern everything. It focuses on a few specific issues. And in the case of credit cards, it's primarily designed as a consumer protection device. We see the same thing in the payment arena, and we're starting to see the same thing with respect to identity systems. So if we look at my diagram here, this is level 2, which we've added to the diagram. Again, it's public law. It comes from governments at some level in some way, and it's a variety of things related to identity systems. So on general law, this is written specifically for identity systems. Now, the level 2 law, as I said, is new. There's very little such law in existence right now. The laws that do exist are written at a very high level, and like the credit card rules, they typically address a very limited set of issues. And most importantly, they don't address all of the issues you would normally want to address in the context of operating an identity system. And they may or may not help from a trust and interoperability standpoint. It really depends on how these laws are written and what their goals are. But just to give you a very quick snapshot of some of the key initiatives that are involved at level 2 that are currently going on with respect to identity systems, perhaps one of the most notable in the US is the Virginia Electronic Identity Management Act. It has a very limited purpose. It's designed to address the question, what's my liability? And it's designed to provide a safe harbor for identity providers, basically saying, if you follow a certain set of rules that we have sort of preordained, a certain standard, what have you, if you follow that standard, you will not be liable if something bad happens. If you don't follow the standard, then all bets are off and you're on your own. Now, Virginia has set up a commission to figure out what that standard should be. And they're working, I'm not quite sure where they are in that process, but I don't believe they've finished the work. But in any event, that's one approach to a level 2 law. Another one we see in Europe called the EIDAS regulation, which governs systems primarily for use in the public sector only. But it's designed to provide to define and provide levels of assurance for identity credentials used across basically country boundaries for public sector purposes. And Vermont, literally within the past couple of weeks, enacted something called the Personal Identity and Information Trust Company Act, where they are trying to define a new kind of corporate entity that would operate some sort of identity systems, but would have the obligations of a fiduciary with respect to the data subjects whose identity it is asserting in various circumstances. I have no idea where that statute is going or how many people will want to adopt the approach, but remains to be seen. A couple of key things in process. There's a group called the Uniform Law Commission in the US which drafts laws for all 50 states. They're just models, and then it sends them out to the states and it says, we think you ought to enact this law, and oh, by the way, if you do, and all the other states do, we'll have consistent laws across the country. They set up a study committee to look at the issue of drafting identity management legislation, level 2 law. The study committee ultimately concluded it was too early and that they were going to wait and see how things developed. But at the same time, the United Nations has a very active project that's just getting started to draft international legal rules for identity. It's the Commission on International Trade Law, known as UNCITRAL. They met last April in New York. We'll be meeting again next November in Vienna at the UN to try to further that project. But that's something to keep an eye on. But here's where I think the rubber meets the road, and here's the area you need to really focus on, and that's level 3. Level 3 are the rules specific to a particular identity system. So from the credit card perspective, think the Visa rules or the MasterCard rules. Same thing with identity systems. We're looking at rules for a particular identity system. They're typically written by the parties involved in the system. It might be the party that sets up the system. It might be a group of participants. There's a lot of different ways to do it. But the bottom line is they are focused on the particular system involved. And they address a lot of very basic and very fundamental issues important to the operation of the system, such as how is it supposed to work? What are the parties supposed to do? Technical issues. How are you formatting the data? What kind of standards are you adopting? What are the various roles that we have for participants in the system, and what are their responsibilities with respect to their roles? When, for example, should a credential be revoked? Or what kind of warranty is made in the context of making an identity assertion? These are all rules that basically the parties make up themselves, as well as legal rules. What are the rights and obligations of the parties in the context of liability? How are we going to allocate liability risks among the group of participants? These are all things that the participants can adopt themselves when the system is set up. So this is sort of just a very brief, high-level overview of kind of the type of things you might cover in the context of system rules. Technical specs, how you issue credentials, authentication requirements, reliance requirements, identity proofing, on and on and on, as well as legal rules. You know, who has liability for what kind of warranties are being made, how are we going to calculate damages, how are we going to enforce various provisions, and so forth. The key thing here is that because these rules are made up by the parties or by the participants or by whoever sets up the system, they're not enforceable in and of themselves. We need a mechanism to make them enforceable. That is typically done through contract. Just like you have a contract with the bank that issues your credit card, which I know you all read those carefully, right? I'm not sure anybody's ever read those except the lawyers that write them. But you have a contract for your credit card. Same kind of concept potentially could apply here in the context of an identity system. But you need some vehicle to make these rules enforceable. So why do we want rules at level 3? 3 basic reasons. First and foremost is a very functional goal. We want the system to work. We want the system to function as it should. Everybody needs to know what they're supposed to do, what the data formats are, what their responsibilities are, and so forth. So we define those. But then we want to go another step and say, in addition to merely working, we want it to be trustworthy. You know, for example, communicating credit card data, I can just email credit card data to you. But there might be some security issues. But leaving those aside, it works typically, right, if I send you an email with a credit card. But if we want to add trust, we might implement something like SSL or one of the other protocols that are out there to encrypt that credit card information. Same thing with the rules for an identity system. We want to add rules designed to build trust into the system, levels of assurance, encryption, what have you. We want to add that trust. And then finally, we want these rules to address the legal issues. Who is responsible for what? This is the place where we try to change the problems or fix the problems with that level 1 law. We try to change what we can change or make consistent across jurisdictions whatever rules we can. Sometimes we can't do that, but to the extent we can, this is the place to do it. So at the end of the day, this is the sort of the structure of the legal model applicable to identity systems. You've got general law at level 1, system type specific law at level 2, both of those enacted by governments. And then at level 3, you have individual sets of system rules for each particular identity system, typically enforced by contract, but designed to address the specific issue of the particular identity system. And then so this is really where you can build in the trust. And this is really where you can control what problems you see or inconsistencies you see, particularly in that level 1 law. So I think, yeah, so that's sort of a quick overview, and I actually think I'm probably a little bit out of time here. But that's a quick overview of sort of the framework for the law that applies to identity systems. Happy to answer any questions if anybody has any, and thank you very much. The challenges in making these contracts work cross-border are when you run into laws in various jurisdictions that in effect say, and you can't change this rule. If you can't change the rule, then you can't do it by contract. But many laws just provide a default, and you're allowed to change them by contract, and so that's what you're trying to do. But in some cases, you can't. Consumer laws, GDPR, are good examples. Yes?
Do you have any examples of the types of cases that are coming up around this?
The short answer is no. We're not seeing a lot of litigation regarding identity systems yet. But what we're seeing is a lot of people afraid to get into the business because they're concerned about their liability risk, for example, or they're concerned about their uncertainty. And so that's really kind of the first challenge, and then we'll get on to the next one. There is some case law with respect to passwords, for example. Lost passwords, what's my liability? What's the liability if my spouse uses my password? You know, maybe in the context of a divorce, and you know, there's those kinds of oddball cases, but otherwise not a lot of litigation yet.
Similar question on the legislative side, over here.
I can't. Oh,
yeah.
Oh, I'm sorry.
I was wondering if you have any insight into sort of trends in terms of the states making different rulemaking.
One of the big concerns of the Uniform Law Commission is that different states are going to do different things, and we're going to end up with a real mess. That's the way the whole electronic transaction, electronic signature field started until the Uniform Law Commission came in and adopted a general law. So that's kind of what got them going. Right now we have Vermont and Virginia are the only two states that I'm aware of that have actually passed something. And they're, of course, totally inconsistent. So that remains to be seen, but that's a big concern if states start going in different directions. Yes?
Are you surprised that we don't see more federations in the different ecosystems today?
Yeah, I am, actually. But I think what's holding the federation issue back in many cases is that concern about liability and the concern about complying with all the various requirements in all the various jurisdictions. And just to give you an example, there's an old system you might be familiar with called Identiverse that was started up in the late 90s. It was a PKI-based identity system. And they literally, from what I'm told, spent almost $30 million trying to develop a set of rules that would work in every single country around the world. Now, I think things have maybe gotten a little simpler since then, but maybe not, I don't know. But I think that's one of the things that's starting to hold, that problem is holding things back as well. Oh, okay, I guess I'm